Okay.
Okay.
Yeah, like Steve said, I'm the president of the Atheist Community of Austin. I'm also an out lesbian. I've been in a relationship with the same woman for 15 years. We had a child together. So I had a personal interest in the outcome of this case. Texas being a common law state, the fact that my wife and I have introduced each other as spouses for all these years, we are actually considered married under common law in Texas. So no marriage license required. However, we will get the marriage license because we're both retired Army officers and the military doesn't acknowledge common law marriages. So anyway, like I said, we had a personal interest in the outcome of this case. Just as a personal note, I happened to be in the Washington, D.C. area on June 26th when this decision was announced. I was actually at Pax River Naval Air Station in a cell phone dead zone. So at 9:59 Eastern Time, Supreme Court announced this decision's at 10 a.m. Eastern Time. So at 9:59 Eastern Time, I was out in the parking lot holding my cell phone up at just the right angle to, suck some electrons out of the sky and get the tweets announcing the decision. So I didn't find out about it in real time there. But it was pretty cool. And later that day, I ended up back at the nation's capital, just on my way out. And it was an unbelievably festive mood out there, just because of the decision. So it was a great place to be. I only wish now that I had brought my family out for the weekend. We could have celebrated the decision there. But I have a presentation I'm going to show you, and then I'll be happy to entertain any questions. I'm not a legal scholar or anything of the sort, so, I'll do the best I can. But if you have questions, let me know. So we'll go ahead and get started. I guess, first of all, what's marriage and why does it matter? And what we're talking about here is civil marriage. And this is really a social and legal contract, and it establishes legal rights and responsibilities between people. It also establishes rights and responsibilities to any children in the family and also to in-laws. And this is actually a marriage without religious content, and it's governed by whatever the marriage laws are in whatever jurisdiction you happen to be in. This also confers benefits that can't be obtained any other way, and I'll talk about that in a little bit. Basically, denial of civil marriage made gay and lesbian people legal strangers. So the impact of that, you can see in the list of benefits of marriage here. Again, this is just a subset of the benefits that you get with marriage, and you can't construct any other contract that confers these benefits. So that employment assistance and transitional service for spouses and military members, military doesn't recognize common law. And only a few states actually have common law marriage. And if you are considered married in a common law state, you move to a state that doesn't recognize common law, guess what? You're not considered married anymore. Okay. And again, things like sponsoring your husband or wife for immigration benefits. If you can't get married, you can't call them your spouse and sponsor them for benefits. This has actually affected a lot of people. And again, veterans' disability, Social Security, family-related rights, next of kin status. You can designate somebody to make medical decisions for you, but you can't construct something that makes them your next of kin, like a marriage certificate does.
Can there be just like a legal union, like, this is going to sound simple, but like forming a company between you and your intended spouse that gives them the legal rights?
You can do that, but you still don't get spousal rights. So it doesn't make them your next of kin. You couldn't sponsor your business partner, which would basically what you'd be doing.
Yeah,
You couldn't sponsor them for immigration benefits unless you called them an employee and had other immigration rules for that.
But they could inherit from you through a corporation or something, couldn't they?
That's a little tricky because one of the things that that you get is this tax-free transfer of property between spouses.
Mm-hmm.
Your business partner doesn't get tax-free transfer of property. So,
Okay.
and the other thing is, if it's a corporation, then the corporation technically owns it. The individual doesn't.
Yeah.
So there's all kinds of legal ramifications to that. The joint adoption and foster care. In a lot of states that allowed gay and lesbian couples to adopt, they had restrictions that said that only married couples could jointly adopt. But if gays and lesbians were prohibited from being married, that meant that one partner had to adopt the child. Then the other partner, if permitted, could go in and be adopted as a second parent afterwards. So it's basically 2 adoption hearings.
Yeah.
Okay, and adoption hearings are not trivial. I actually had to adopt my own child in Texas as his second parent. This is a child that my wife and I planned him together. We picked the donor together. I was there for every prenatal appointment. He was there when he was born, the whole 9 yards. By any definition, I was his parent. But the state still said we were legal strangers. And so I had to adopt my own child. Cost about $4,000 because what you have to do is go in and petition a court, and it has to be a joint petition, so you and the child's biological parent have to petition the court jointly. You have an attorney that represents you. You have to hire a second attorney to represent just the child. So you get 2 attorneys, the judge. You have to get a criminal background check, and you have to get a social worker come in and do a home study to say that the home that the child was born into is suitable for you to raise the child. Okay.
Well,
If we had been a heterosexual couple, even an unmarried heterosexual couple, in exactly the same situation, child conceived with donor insemination, all this stuff, I could have just put my name on the birth certificate, given mine from birth.
yeah.
So, like I said, there's huge implications for denying spousal benefits.
Yeah.
So, if your spouse is in most jurisdictions, the requirement is that spouses must jointly adopt. One spouse can't adopt a child independently of the other, which makes sense from a child welfare standpoint.
Well, a single person in the South, I believe, it's real difficult to get allow a single person to get adopted.
That's actually not too difficult.
Is it not now?
Yeah, most jurisdictions it's not too difficult for a single person to adopt.
Mm-hmm.
The problem is if you're not a single person, if you're a gay couple,
There's a problem. Yeah.
previously you couldn't. And that's still kind of a little bit in limbo right now. We're going to have to get some clarification from the courts in Texas in particular. So there's a couple of other things. The last one here is kind of important. You have the right to a divorce. Okay? And if a relationship breaks up, these things can get really contentious and they can drag on for years. The right to a divorce is kind of critical because then you have a judge that's going to say, okay, we're going to divide up the property from the relationship. We're going to, agree on terms. There's going to be a decree, and that's it. And you can move on with your life instead of, coming up with things over and over again over a period of years. I've known people that have broken up with people they were in relationships with for years, and the breakup took years because the person that didn't want the breakup kept coming back and saying, "Oh, you owe me this," or "You still have this that's mine." It just never ends. Yes.
I was glad you mentioned common law because I have not heard anybody mention that with regards to gay couples. But essentially, there's a lot of gay couples out there that became married as soon as that decision went down. In almost every legal aspect there is. And that's often not something, they want. So they should sort of be aware that they're now legally married.
Well, only if they hold themselves out to be married.
That's not necessarily true. If there's a few things, if they do that, then they will be legally married, even if they don't tell everybody that they're legally married.
If they make it clear they don't consider themselves married, then they're not married under common law. And if they break up, then each party only has, I think it's 2 years to claim that they were in common law marriage. After 2 years have elapsed, it's like it never happened.
Yeah.
Okay. But yeah, The critical thing for common law marriage is that you hold yourselves out to be married.
I've heard, I used to work in a title company, and it came up occasionally. It's usually not something both parties want, but if you hold a joint bank account, that's almost a ticket to being common law married.
Like I said, it really depends. If you don't hold yourselves out as married, then it's hard to make a claim for common law.
What does that mean, hold yourselves out?
If you introduce yourselves as husband and wife, or wife and wife, or if somebody assumes that you're married and you don't correct it, that could be construed as holding out. So you show up to your kid's PTA meeting or something like that, and everybody introduces you as a married couple and you correct it. That could be considered.
There are physical things like a bank account and a postal address and things like that.
Those can be elements of it, but the critical thing is holding out.
Yeah.
So
presenting yourself as.
Just cohabitating is not enough. Okay, so let's keep going here. So there's a lot of misconceptions about marriage as an institution. The reality is this is an evolving institution. A lot of people think, even a lot of atheists say, it's primarily religious, we shouldn't even care. Let's just call it something else. They think it's the traditional marriage, the husband, the wife, and their kids has always been the norm. That actually didn't become the norm until fairly recently. Or that it's primarily for procreation. Historically, it hasn't been primarily for procreation. There's a couple of milestones in marriage that we can talk about here. First is that historically it's been a vehicle for creating and strengthening family ties and political alliances. So by that I mean, for example, there were in some cultures rules that you had to marry within your own social caste, okay, and that served to strengthen alliances within the caste. There were other rules that said you had to marry outside your own social caste. This concept of exogamy. And that was to foster alliances with other groups. Okay. There's also, the European royal families had a habit of trading their daughters around to establish political and military alliances with other countries. So that was one of the primary vehicles for marriage historically. And this has been going on for even centuries before even the European royalty rose. With regard to strengthening family ties, interesting little factoid. Historically, most marriages have involved first and second cousins. And in fact, some DNA analysis puts this at around 80% of marriages throughout history have been among first and second cousins.
Because of proximity, probably?
What's that?
Because of proximity to a mate?
Proximity and this idea of endogamy, where you married within your social group. And a lot of times that meant cousins getting married. And these kind of consanguineous marriages right now are around 10%. So that percentage has dropped significantly.
Is that against the law?
In some jurisdictions it is. Not all jurisdictions in the U.S. criminalize marriage between first cousins. I don't know of any jurisdictions that don't permit second cousins to marry, but there are some that don't permit first cousins to marry.
Well, that's how my book got all kicked off too. They were all inbred, current cattle, I think.
What's that?
In the Bible, biblically, that was the norm because there was not many people to choose from.
Well, I mean, it was the norm throughout most of the world for a long time.
Well, after the flood, there were only 8 people.
Yeah. So this idea that procreation was required, actually, procreation has rarely been a prerequisite for marriage. And surprisingly enough, the Catholic Church was one of the first major institutions to come online and say, no, kids are not required. The rule from the Catholic Church was, if you can have kids, then you should. And basically you should enter into it with the intention of having kids. But if, for example, the couple proved to be infertile, that was not grounds for dissolving the marriage. If, however, the husband was unable to have sex with his wife, that was grounds for divorce or annulment.
It's in our countries too.
Yeah. So
today,
there was this idea that you're supposed to be having sex, but you don't necessarily have to have kids. Again, another one of those rules that the church has for people. This idea of polygamy versus monogamy. Polygamy was actually the norm for a long time. So polygyny in particular, so multiple wives. So molecular genetic studies show that this was typical until we shifted to an agricultural society between 5,000 and 10,000 years ago. So for most of human history, some form of polygamy has been the norm. However, I will note that in any culture, polygamy or polygyny in particular is generally restricted to wealthier men.
Sure. Is there a resource where we can look up on those studies that genetically indicate polygamy?
I don't have a reference at hand, but if you scroll through Science Magazine's archives, any article that's over your own is free, so you can find a wealth of information on genetic studies there.
Great, thank you.
Sure.
what was the polygamy or polygyny? I don't know.
Polygyny. Okay, so there's polygyny, which is multiple wives. Polyandry, which is much less prevalent, is multiple husbands. That one is actually also associated with what's known as partible paternity, where the view is that children have multiple fathers, and a pregnant woman is expected to have sex with multiple men because the semen of multiple men is necessary to produce a healthy child. So,
that actually, that where I've just seen where they have this a lot in places like in the Himalayas and Tibet. And,
yeah, Himalayan tribes are
where there's just a shortage of available women, and so a group of brothers will marry. They'll be married to the same woman, and she'll. I think it was David Attenborough was talking about this, where she's nursing a child who is her husband.
Yeah.
Who's the brother of her other husbands.
Yeah. So there's also I think it's in China. There's I forget the name of the culture, but they practice what they call walking marriages, where the men don't actually reside in the women's households. The women own the household, and they basically wield political power, and the men travel from household to household, basically.
Spreading STDs.
Not so much there. I mean, it's considered a type of marriage, and they basically are invited in a night or whatever, but they don't actually live in this house. So monogamy was, unsurprisingly, influenced by the church, but it didn't actually become central to marriage until around the 9th century. And the rise of monogamy is statistically correlated with a shift, well, actually the size of different communities. So the larger the community, the more prevalent monogamy became. And it's also correlated to a belief in morally concerned gods. So like the Abrahamic religions, as the size of the societies grew, they began to promote monogamy as a norm. There's also a concept of monogamy light, or as Dan Savage likes to call it, monogamish, but only for men. So male promiscuity was sort of expected. Female promiscuity was heavily sanctioned. So you had guys who rode off to the Crusades and left their wives in chastity belts or whatever. So. And then there's this idea of state versus church involvement. There's this belief that marriage is owned by the church, but actually the church was a relative latecomer to marriage. Most marriages in Europe until around the 16th century were by mutual consent, which basically means you walked up to somebody and and you mutually agreed to enter into a marriage, all you had to do was say, "I marry you," and then cohabitate, and you were married. Okay, you didn't need witnesses, you didn't need a priest or anybody to sanction it. It wasn't officially recognized as a sacrament in the Catholic Church until the Council of DOMA in 1184. At that point, it became a sacrament. And then around 1215, the Catholic Church began requiring people to publicly post a notice of their intent to marry in a local parish. And that kind of got the church involved in recording marriages for communities. So if you wanted your marriage officially recorded, you posted the notice with the local parish. Now, during the Protestant Reformation, Martin Luther viewed marriage as a worldly thing, and he didn't think the church really ought to be involved in that. And so, from about the 17th century on, there basically became a civil component of marriage that didn't involve the church. And that was, again, the Protestant influence. Civil marriage in the U.S. Actually began in 1639 when Massachusetts began requiring marriage licenses. And by the 19th century, marriage licenses were common in the U.S. There was still a concept of common law. Now there's only a handful of states that recognize common law marriage. So that's kind of on the way out. So some of the more recent influences on marriage, market economics. Basically, this transition from an agrarian to an industrial society meant that young people who wanted to get married had more options. Back when agriculture was the big deal, a young person who wanted to get married, especially a young man, he was looking at inheriting land or other property from mainly his father. And so in order for him to have enough wealth to support a wife, he had to get his father's permission to marry someone. So there were lots of still arranged marriages or parents picking spouses for kids. And so it wasn't this idea that two people met, fell in love, and decided to get married. Young people in agricultural societies, even today, still don't have that kind of choice. The transition into a market economy meant that you had your own resources. And so you didn't need permission from your parents because you weren't dependent on your parents' wealth in order to support your family. But it was still at one time regarded as the most important financial decision in a young person's life. This idea of marriage for love was very uncommon until about 250 years ago. It's only been in like the last 100 years or so that mutual attraction was considered important in a marriage. But this concept of a love match is what gave rise to this nuclear family that we think has always been in existence throughout history. Changing gender roles had a huge impact on marriage as we know it. Up until about 40 years ago, a wife had no legal identity of her own. So there was a time not that long ago when in lots of jurisdictions a woman could not, if the woman was married, she could not have her own bank account, she could not have her own credit card or credit in her name at all. She couldn't buy any real property on her own. Everything she did required her husband's consent. Her husband did not have to have her consent to do any of those things.
Or fathers.
Well, no, I mean, this is for married women. So, once a woman got married, she had no legal identity separate from her husband. So that's changed now. Now we regard marriage as a partnership. And this idea that, this actually changed about 50 years ago. Now we view it as, we each have equal obligations and rights. The marriage is for companionship, and it's based on mutual sexual attraction and other intrinsic factors, separate from obligations or alliances or anything else that might do to benefit a third party. So this idea that that marriage as an institution has somehow been radically redefined in the last few weeks. History kind of refutes that pretty neatly. It's been in evolution for a long time. Interestingly enough, though, the people that oppose marriage equality largely don't recognize evolution as a thing. Speaking of marriage equality opponents, they've been losing their minds. Okay, so let's talk about a couple of key players here. There's a lot of people out there that don't like this ruling. So I could not possibly talk to you about all of them. Right Wing Watch is a great website if you want to go take a look at some of the real crazy stuff. The big one is National Organization for Marriage. So this is a 501c4 nonprofit, so basically they're a lobbying group. They were founded in 2007 specifically to oppose marriage legislation in states. That is an awesome thing. Let's form a 501c3 lobbying organization to promote inequality. What a great thing.
And they openly say that's their...
Yes, that's...
They do.
Yeah.
How are they able to be a 501c4?
501c4s are political lobbying groups.
They're still tax-free.
Yeah, tax exempt. However, there are some differences. That is specifically for lobbying. So if you donate to a 501c4, that's not tax deductible for income tax purposes.
Well, I mean, their operation as an entity is tax-free and everything.
Yes, they're a nonprofit.
Yeah. But isn't that a pretty obvious? Isn't that the marriage that they propose is mostly based on religion, on biblical teaching? So now the government is making a special law for them.
No. 501c4s are available to anybody.
But I'm saying that the purpose of that is to promote pretty much a religious agenda.
Which is permitted under 501c4 regulations.
Yeah, doesn't that go against, what is it, Second Amendment, make no laws?
No, Second Amendment's the right to arm bears.
Whichever. To make no laws to
Respecting the establishment.
Yeah, that's the establishment clause.
That's not a law.
But yeah, that's part of the establishment clause, the First Amendment. But no, 501c4s don't violate that. They're specifically for lobbying. So basically, the rules for 501c4s are different than the rules for 501c3s. For example, if you donate to the ACA, or a 501c3 educational organization, we don't engage in any kind of political lobbying.
Yeah.
Okay, your donation is tax exempt for us and tax deductible for you. So if you donate to a 501c4, it's not the same thing. So this was specifically developed to allow groups to lobby on behalf of certain issues. So one of their co-founders, Maggie Gallagher, she likes to brag that we fight gay marriage and win. Maggie's very, very sad. The other co-founder, Brian Brown, he has compared the recent SCOTUS decision on marriage equality to the Dred Scott decision. In other words, he's saying that marriage equality is just like slavery. Yeah, he's very sad today too. They actually helped raise the early money to get Proposition 8 on the ballot in California. I've got another slide that talks about Catholic Church's involvement in that, but basically a Catholic bishop in California invited them into California to work on Prop 8. That was the constitutional amendment that banned gay marriage. The ballot initiative in California that banned marriage in California. He argues that marriage equality harms what he calls the culture of marriage and demeans children into options. He doesn't really have a lot of concern for my child, for example, who benefits greatly from having a legal relationship with both his parents and having his parents have a legal relationship. They're now calling for a constitutional amendment defining marriage as the union of one man and one woman. So
I don't understand the methodology for not letting a man marry as many other men as he wants to, and a woman marry as many other women as they want to?
Well,
I mean, why would where would the government have?
well, that's kind of a separate issue, so we want to talk about that.
You're going to get to that? Okay, good.
So the Catholic Church, their longstanding opposition to anything that might benefit the LGBTQ community is well documented. Their message is marriage equality is a very bad thing. It's much, much worse than that pedophilia thing. So, there was actually a Catholic bishop in California, Salvatore Cordileone, and he's regarded as one of the architects of Proposition 8. He was recruited early on by some marriage equality opponents, following some court decisions that basically legalized marriage, same-sex marriage in California. He had the contacts and the organization to get people going in California. And he invited the National Organization for Marriage to come in because they had basically the infrastructure and the money to get this going. And Catholic Vote, this is a conservative nonprofit group, recently produced a video. Some of you may have seen it going around on social media. It's a bunch of anti-equality Catholics who are appropriating LGBTQ themes to marginalize LGBTQ people. So they're basically claiming that they are the ones being oppressed by this marriage equality position. So they're all very, very sad. The Mormons were also a major player in California's Prop 8 fight. They were also invited in to participate in this. The LDS president encouraged Mormons to donate money. So between the church and Mormon families donating to the Prop 8 campaign, they contributed nearly $25 million to that. So it's a huge sum of money. However, that involvement backfired because they had a wave of resignations from the church as a result of that. Turns out there's a lot of Mormons that have gay family members that are deeply offended by the church officially sanctioning this.
They're reading a statement in church either today or last week supporting marriage being one man, one woman. So that'll get another wave of people getting pissed off, I'm sure. Yeah. Well,
if that's how they want to be in their church, I don't care. That will have no effect on me. What's objectionable is them trying to influence legislation that affects everybody, even people that don't subscribe to their beliefs. Family Research Council, you guys know these guys.
It's not against the law for a nonprofit organization to actually donate money to a political activism syndicate?
It depends. If it's an issue, you can use your organization's resources to support issues, but not political candidates. And then there are limits on lobbying. And that's why most of the time if people want to do extensive lobbying, they form a 501c4, which is explicitly a political lobbying group. And so you can...
But the C3 can donate to the C4?
Yeah. Oh, which is basically what happens with Family Research Council. So this is it was formed by James Dodson as an arm of Focus on the Family, which is 501c3, 501c4 lobbying group. You guys know these guys. They hired Josh Duggar because marriage equality is way, way worse than pedophilia. So the current president, Tony Perkins, he's a former Louisiana state representative. He founded this Louisiana Family Forum because of what he saw as the increasing influence of the homosexual community on public policy issues. Because
I would say that caused Katrina.
Yeah.
So be careful.
Yeah. And you can see that, there's such a huge gay lobby in Louisiana these days. They're just taking over the place, right? And he still maintains that homosexuality is inherently wrong and therefore same-sex marriage will never work. there's at least two of us in agreement.
And this is coming from somebody
That's wrong.
that promotes heterosexual marriage, which has about a 53% failure rate.
Yeah. They're also very, very concerned about how straight people should explain gay people holding hands to children. So,
Because that's what needs to be explained.
and what I've had to explain things to my son. First of all, he's been raised in a household where his parents are both women. So two women together, two men together, it's not a big deal for him. We're just his parents, right? And explaining two people who love each other to a small child is very, very easy. Explaining to him why we don't go to Chick-fil-A. They spent $25 million trying to kill people like us in Africa. That's a little bit more difficult. Yeah.
Doesn't a family research council also have all kinds of bizarre and baseless positions on things like masturbation?
Oh, yes. Yes.
I just thought, I wasn't sure that it was the same.
And they support reparative therapies, various works. And
So that is one I was
if
thinking
you
of.
can't successfully complete reparative therapy, you're just supposed to never have sex with anybody. Yeah.
Gay people are pedophiles, but
Yeah.
no mention of Catholic hierarchy when pedophiles brought up on their website.
Or the abuses in their own ranks.
Mm-hmm.
Josh Duggar and the other thing is I believe it was FRC that was associated with George Riekers, who was the guy that claimed that reparation therapy was valid, and so it resulted. Basically, he misrepresented some other work, used it to support his thesis, which the author of that other work came back and said, that is not what my research says. It actually says the opposite of what you're using it for. And anyway, based on this, there were some actual suicides of gay kids who were subjected to this abusive reconditioning therapy. And George Riekers was the guy who got caught on video with the Rent Boy, which prompted, basically he said, oh, he was just a traveling companion. I hired him to lift my luggage because I hurt my back, and Dan Savage was making fun of him. Like, oh, is that what we're calling him now, lifting your luggage?
The Southern Poverty Law Center can list them as a hate group.
Yes, they are listed as a hate group.
Dobson's group is listed as a hate group.
FRC is, yeah.
Okay.
So this kind of gets us to some historical context of where, how we got to this SCOTUS decision. And to be honest, the difficult part in constructing some timelines that I'm going to show you on the different court cases was not finding court cases. It's finding which ones I needed to exclude because there are so many court cases out there. It was just unwieldy. So I probably missed a few important ones. The ones I'm going to show you kind of illustrate the way things have been going since about 1965. And again, I'm sure I missed some important decisions. I apologize for that. It was just, there are so many out there. And I couldn't even deal with the legislation after looking at the court cases. It's like, there's legislation, but I'm not even going to talk about that now because it's kind of been...
Hey, one quick question.
Yeah.
When did the American Psychological Association, when did they decide it's not a sickness?
I think that was in the 70s when they changed. I think it was DSM-3. It was published in, I forget what year in the 70s, but that's when I think they dropped it.
Those are early 70s.
Yeah.
73.
Yeah, it was fairly early on. So some court decisions prior to 2000. So give you a little bit about the kind of the code here. Anything above the line is in support of equality or equal recognition or striking down an unjust law. Anything below the line is upholding what has later been found to be a discriminatory law. So kind of gives you a visual on what we're looking at here. First one I want to talk about is Griswold v. Connecticut. This basically held that there was a constitutional right to privacy between married couples with respect to certain intimate practices, and this specifically addressed the issue of contraception. And you're probably wondering, well, what does that have to do with gay marriage? Well, it established this right to privacy with respect to intimate acts between people. And Griswold was specifically addressed toward married couples. So it didn't extend beyond that. But basically it said that you can use birth control. And it's not the state's business if you do or you don't. Prior to that, certain jurisdictions criminalized even the possession of birth control. So if you had a condom in your pocket, you could be arrested issuing birth control. And just to give you some idea of the context for this, in World War II, American soldiers were the only troops that were sent to Europe without condoms. Every other military sent their troops out there with condoms. Okay. So we had to get over some stuff. Okay. Loving v. Virginia, I'm going to talk about separately because this is a really huge case, and a lot of other court cases have relied on the Loving case to advance marriage equality in general. Eisenstadt v. Baird basically did for unmarried couples what Griswold did for married couples. It established the right to privacy with respect to intimate acts and says that even unmarried couples can use birth control and it's not the state's business. So we can see what's happening here in the 60s. Baker v. Nelson, that actually, here. Baker v. Nelson was actually a Minnesota Supreme Court ruling that said that limiting marriage to persons of the opposite sex didn't violate the Constitution. So that was like one of the first cases that looked at the issue of marriage equality. It was back in 1971. But it said that the state had an interest in restricting marriage to just straight couples. And so the rest of these cases that are up here are primarily dealing with the issue of sodomy. Various state and district courts ruling on sodomy statutes and their constitutionality. So you see that the way things were moving is that most states or most courts were striking down the sodomy statutes. So we ended, the 1990s with most of the states having either repealed or had their sodomy statutes struck down as unconstitutional. There were still about 13 states that had sodomy statutes on the books, and a lot of them had sodomy statutes that governed only homosexual conduct, not heterosexual conduct. So with that, let's talk a little bit about the Loving decision, because that's so pivotal to a lot of the cases. This was 1967. So in 1967, 16 states had laws like Virginia's Racial Integrity Act of 1924 that said any kind of marriage or even a sexual relationship between a white person and a non-white person was a criminal offense.
Well, they could have arrested Thomas Jefferson.
That was one of those monogamy-like things. Basically, they were charged under what happened was the Lovings wanted to get married, and in Virginia they couldn't, so they went to Washington, D.C., and they got married. And then they went back to Virginia, where they lived, and took up residence in their home. The police were tipped off one night, showed up, and arrested them. They actually raided their home in the middle of the night, hoping to find them having sex. What they found was them sleeping in their bedroom. So they arrested him under Virginia's anti-miscegenation law, and basically they were charged. They ended up pleading guilty. They were given a 1-year suspended sentence, provided they agreed to leave Virginia. Well, they did. They moved to D.C. But the problem with that was that they had family in Virginia, and they couldn't visit their family because if they went back to Virginia, they were subject to arrest and imprisonment. So then they filed a lawsuit, and SCOTUS ruled that Virginia's anti-miscegenation statute violated both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. And Earl Warren, in his unanimous decision in the court, wrote that civil marriage, was one of the basic civil rights of man. So it kind of established marriage as a civil right. It's a hugely important decision. That's why it's considered to be a landmark case. Let me make sure. Oh, and interestingly enough, the state defended this law, saying that it wasn't discriminatory because both parties were punished the same way. So
it actually occurred to me that it was slightly better that both were arrested. I'm not saying it's good. I'm just saying, at least they arrested both of them.
Well, and the other thing is, I included a picture here because it's kind of relevant. The other thing that's kind of important here is that we're talking about a white man and a black woman. Okay? If it had been the other way around, I have a feeling that sentence would not have been suspended. So that was kind of critical there to them getting a suspended sentence in the first place. I'm going to go back real quick and look at a couple of other things on the timeline that aren't noted here, but I want to point them out. Okay, so we get up to the 1990s and we see these court cases starting to go in the way of expanding rights for everyone. And some people are looking at this. One of the things that's happening is that people are clamoring as we go into the 90s for a repeal of the military ban on gay service members serving. And there was actually majority public support for that in 1992. And what happened was we ended up with Don't Ask, Don't Tell, which was a compromise. The reason we had to get a compromise on that was because there was opposition from some key members in the Senate, specifically Sam Nunn and John McCain, who said, we're absolutely not going to support repeal of this. This will be a disaster. So Don't Ask, Don't Tell was enacted as a compromise. It basically said, okay, there's no absolute ban on serving anymore. You just can't tell anybody that you're gay. You definitely can't do any gay things. Unless you can claim you were drunk or you didn't know what you were doing or it was just an immature experiment or something like that. So if you actually committed a homosexual act, then you came back like, oh yeah, I know, I was drunk. I'm totally not gay. And you just stay there.
I slipped.
Yeah. If you came in and said, you know what, I'm gay, but I'm totally celibate, you were out. Didn't matter what job you had, how valuable you were, you were done. So basically it says lying is now the acceptable standard, in fact the required standard in the military. And then in 1996, the Defense of Marriage Act was passed. So there were some people that saw the handwriting on the wall that things were moving in the direction of people getting married. And so the Defense of Marriage Act was this idea that even if the states recognize marriage, the federal government won't. We won't grant federal benefits to same-sex couples. So that became enshrined in law. So it didn't matter if you got married in your state, if you got married in Canada, or anywhere else where you could, you still couldn't be recognized by the federal government. So let's keep going here. So after 2000, same thing. If it's above the line, it's sort of a pro-marriage equality. Below the line is anti-marriage equality. And look what's happening in the courts. And again, this is a subset of the court cases out there. Most of these court cases from here on concern rulings on marriage equality. Lawrence v. Texas is one I'm going to talk about in more detail.
Is the first name the plaintiff or the defendant or the
yeah,
order of
Yeah, this follows the typical way of naming court cases. These are the official court cases. So, like for Lawrence v. Texas, Lawrence is the plaintiff in the case.
Okay. I've been noticing the states have been on both sides.
Yeah. Yeah. Okay. So we've got Lawrence v. Texas, which is considered a landmark case. As we move further on, we've got United States v. Windsor, which is a hugely momentous case that kind of set the stage for the Obergefell v. Hodges case.
These are all federal court.
Some of them are actually like state courts. Like I said, these are just the ones that are kind of critical. So, like in regards to marriage cases here, let's see if I can. So here, all right. So right here, in marriage cases, this was actually the California Supreme Court that aggregated about 6 cases that were similar and considered them all together. So that was an aggregate. Let's see. I think, if I recall, Goodrich v. Department of Public Health, this was the one that made marriage legal in Massachusetts. So, Hernandez v. Robles actually upheld a New York ruling that restricted marriage to same-sex or opposite-sex couples only. And that was overturned by the legislature in New York. All the people that were saying that, there's judicial activism and, the judges are writing laws and everything, they weren't upset about Hernandez v. Robles at all. They had no problem with that. So anyway, let's move. Perry v. Schwarzenegger. This was actually Judge Vaughn Walker in California. The plaintiffs that brought the Proposition 8 legal challenge. This was the case that Judge Vaughn Walker heard. And he did a brilliant legal analysis and fact-finding study in the course of this case. Really laid it out well. So when I went to the Ninth Circuit, they said, yeah, there's no errors here. This is done. And so they upheld the decision. And that's the Perry v. Schwarzenegger case here. That actually went to the Supreme Court because the marriage opponents appealed this all the way to the Supreme Court. And the Hollingsworth v. Perry decision, which was issued on the same day as the Windsor decision, what they did was they said they issued a summary judgment upholding the Ninth Circuit's decision because they said that the plaintiffs had no standing. So in order to have standing in a court, you have to demonstrate that it's not just that you just don't like the other court's ruling or that it offends you in some way. You have to demonstrate that it actually causes harm. And not just theoretical harm to someone, but harm to you. You have to have personal standing in order to bring the case.
Skin in the game.
Yeah. And what they said was that you guys don't have any standing in this case. You're not harmed by this decision. So that was a summary judgment that sent it basically, just affirmed the Ninth Circuit's ruling. Sent it back down. So that effectively ended challenges to marriage equality.
Windsor was DOMA, right? The Windsor case was DOMA?
The Windsor case is DOMA. Yeah, we're going to get into the specifics here, so let's go ahead and move on here. So Lawrence v. Texas. So this one originated when John Lawrence and Tyron Gardner, well, let me back up a little bit. There were 3 friends. So there was Robert Eubanks and Tyron Gardner, who had this on-again, off-again relationship. It was kind of a contentious relationship. They were friends with John Lawrence. So Gardner and Eubanks were staying with Lawrence one evening. Gardner and Lawrence had been flirting. Eubanks had been drinking. Eubanks got pissed off. He left the apartment to go get a soda. And while he was out, he called the police and said, there's a black guy with a gun in Lawrence's apartment going crazy. So, 4 Harris County deputies basically went into the unlocked apartment of John Lawrence and found Lawrence and Garner in Lawrence's bedroom. Okay. So, 2 of the deputies didn't report seeing either of them having sex. One of the deputies said they were having anal sex. The last deputy said no, they were having oral sex. So there's no one can. And,
so hard to tell.
Yeah, it's like don't talk anything. So there was some concern about the quality of testimony of the witnesses here, but anyway, but they ended up being charged, and it was sodomy is a Class C misdemeanor in Texas.
And it was a good thing.
Yes. Yes, it was a good thing. Because what happened was they went to land the legal, and so Garner and Lawrence agreed, instead of fighting this, they're going to plead no contest, which basically doesn't mean that you're pleading guilty. It doesn't mean that you're challenging it. You're just saying, I'm not going to contest it. So when they were originally fined in court, the judge sent down a $100 fine plus court costs. And the lawyers conferred from it, and they came back and they're like, Judge, the fine is too low to allow us to appeal this case. And the judge said, oh, I understand. You're now fined $125, which met the legal threshold for them to appeal. So the judge was actually on board with the idea that, hey, it's an unjust law, but he had no choice but to enforce the law as written.
It was an unjust law that couldn't be challenged because it was unenforced. And
right.
It was very frustrating.
Yes. Yeah, it was basically used to harass people. And these piddly little fines were all part of the harassment. So you have somebody come in and plead no contest. They get a $100 fine. They pay the $100 fine to make it go away. And the law continues. And so the idea behind this was, let's get the fine up to where we can challenge it in court and actually get it struck down. So they appealed, and the defense argued that it was unconstitutional because it violated the 14th Amendment Equal Protection Clause. So on appeal, the court originally said, no, it doesn't violate the Equal Protection Clause. And they came up with some strange ruling that the state had some interest in, what two consenting adults were doing. Anyway, went to the Texas 14th Court of Appeals that issued an en banc decision that held the law's constitutionality. And the Texas Court of Criminal Appeals declined to hear the case. The Texas Court of Criminal Appeals is notoriously chicken when it comes to big cases. They don't like dipping into these things. And so they typically decline to hear this. They kick the can down the road. So then at that point they appealed to higher courts, and SCOTUS granted cert in December 2002. And on June 26, 2003, they ruled 6-3 that the law was unconstitutional. Now, this opinion specifically overruled a previous decision in Bowers v. Hardwick, and it invalidated the remaining sodomy statutes in 13 other states. So now, what we have is that consensual sexual behavior between adults is no longer criminalized anywhere. And one of the implications of this was that the military, which still criminalized sodomy, actually went in and changed its rule too.
Wouldn't those decisions come from the Supreme Court, would they not automatically cover the military laws? Whole separate thing.
No, military is a separate justice system. Yeah.
There was another little important little tidbit out of that, and that is Scalia sort of said, well, those gays will want marriage next. Yes. And that lit the fire under the whole marriage thing.
Yes, that was one of the things he said, hey, it's open the door for gay marriage. And,
sure we're not.
It's kind of like, damn, we got a hold of our agenda. So this was Lawrence, and then, there were many other court cases involving marriage equality and some legislative actions. This actually spawned a lot of state groups to start banning gay marriage as part of a constitutional amendment to state constitutions. So in 2005, Texas enacted a state constitutional amendment banning gay marriage, which is really interesting because for two reasons. One, it was already banned by statute, but they were going to double ban it. And then the other thing is the law is so poorly written that if you read it just, without understanding what they were trying, they actually banned marriage in Texas. Anyway.
So, seriously, did the 4 deputies you said that did the arrest, they didn't have their story straight?
No.
So how did this go? I don't know much about the courts, but how did this become a legitimate issue? These 4 deputies?
That's how things went. I mean, basically, if you got charged under the Texas sodomy statute, the law enforcement officers, often the way they got the evidence was violating your rights, basically by entering your home without a warrant or without probable cause. And then if they saw something, they said, I saw this. And the courts generally just accepted their word. And like I said, the fines were so low that it was basically just harassment.
Right.
So you issue a low fine.
But doesn't it kind of reflect on the department? I mean,
Texas law, come on.
Right. I suspect that a lot of people probably just went along with the fine because the cost of having reasonable defense was certainly higher than that $100 fine.
Yeah.
Possibly even as late as 2003, people were still concerned about their public reputation, being outed. And in this case, it was being outed as having a relationship with somebody other than his partner.
Yeah. Well, yeah, and I mean, being convicted of sodomy.
Right. It sounds really heinous.
There was not this understanding that most of these charges came about as a result of law enforcement violating your civil rights, basically kicking your door down without a warrant or in some way invading your privacy. So there was no concept of that. There's just this idea that you did it. And the common perception based on some of these anti-gay groups was that if you got caught for sodomy, you were probably doing it somewhere in public.
Right.
And so, you were in a public restroom or a public park or, somewhere where kids could come by and see you. There wasn't this idea that somebody walked into your bedroom without a warrant.
Were they still prosecuting heterosexual couples for sodomy?
No, the Texas sodomy law only applied to homosexual conduct.
So you can put it in, you can have sodomy with a woman and not with a man.
Yes.
And sodomy, I think, is defined as non-procreative sex, right?
Yes.
A lot of folks practice that.
Yes. Well, and bear in mind that, the Supreme Court in the Griswold decision had already established a right to non-procreative sex. So, the state had no legitimate interest in what people were doing in private, unless you're gay. So then we get to Windsor, and the Windsor decision, so Edie Windsor and Thea Spire got married in Canada. They went up to Ontario in 2007. In 2008, there was a court decision in New York where they lived that said, hey, we're going to recognize marriages performed in other jurisdictions. So their marriage was recognized in New York. So they were considered married. Spire died in 2007 and left her entire estate to Windsor. But because of Windsor, or because of DOMA, Windsor couldn't claim the federal estate tax exemption for surviving spouses. And she got hit with a more than $360,000 bill for estate taxes for the death of her wife. So she's grieving the death of her wife, and now she's got this massive tax bill. So she filed suit against the federal government in 2010. And Supreme Court granted cert in 2012. And in the 5-4 ruling, they struck down Section 3 of DOMA, which basically says that the federal government doesn't recognize marriage except for between a man and a woman. The interesting thing about the Windsor case is that the Obama administration declined to defend it. They said, basically, we don't think this is going to survive constitutional challenge. And part of that had to do with the reliance on the Baker v. Nelson case, which is a previous case that used a different level of scrutiny for determining these cases. The Second Circuit, where this was originally challenged, where the suit was originally filed, didn't have that level of certainty or scrutiny. So it was a different standard of scrutiny that was in play here. And so the Obama administration looked at it and said, well, based on this, we don't think we can defend this in court.
Well, how did the Supreme Court have any jurisdiction over this? It just previously you said they don't have any jurisdiction over military law.
This is not military.
But wasn't DOMA pertaining to the military?
No, you're thinking of Don't Ask, Don't Tell.
All federal government benefits.
But does the military fall under that DOMA?
Yeah, the military was restricted by DOMA from offering spousal benefits to anyone.
But then the Supreme Court has the authority to get rid of DOMA, which affects the military law.
But military is affected by DOMA and UCMJ.
Yeah, it's UCMJ is separate from offering spousal benefits. So UCMJ is Uniform Code of Military Justice.
Yeah.
So the military has its own justice system, and it can call things criminal that are not criminal.
Yeah.
For
the Supreme Court doesn't have.
But that can be challenged by federal law.
Yeah. So basically, the military can, and basically Congress can change UCMJ, but that Supreme Court decision didn't have any direct effect on UCMJ. What I can tell you is that the military quietly stopped prosecuting sodomy cases after Lawrence v. Texas. So and actually before UCMJ was enacted, sodomy in the military wasn't criminalized unless it was forced.
Yes.
So,
but I mean, the rule is still under the books on the UCMJ about that, isn't it? The fact that they don't enforce it doesn't mean the law.
No, the law was changed. Sodomy is not a criminal. I mean, consensual sodomy is not a criminal act under UCMJ. Okay. So anyway, so the Obama administration says we're not going to defend this case. And so John Boehner stepped up and formed a bipartisan legal advisory group and stepped in to spend taxpayer money to defend it anyway. So that's how it's funded. Yeah, got defended.
But legally, Obama has to uphold and defend the laws that are passed by Congress, right? So he was in an awkward situation.
He really was. And basically, what he was saying is that, based on our reading of the Constitution, we don't think it's going to survive, and so we're going to step aside. They didn't put any barriers in the way of, flag defending it. But Justice Kennedy said that basically there's no legitimate purpose that overcomes the effect to disparage and injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. This is one of the first times we see this kind of dignity argument coming up regarding the marriage decision. So that was Windsor. And that kind of brings us to the Supreme Court case, which was the Obergefell v. Hodges decision. And so with that, we get treated to the arguments for and against marriage equality. Okay? So in favor of marriage equality, it's basically you're violating same-sex couples' rights to due process and equal protection under the law. With regard to children, we're already raising children, so denial of marriage rights is just putting the children at greater risk. Gay and lesbian couples were often accused of trying to destroy the institution of marriage, or this is somehow damaging it. And so the argument was that a desire to participate in the institution doesn't attempt to demean it in any way. And then, a same-sex couple's marriage doesn't harm anyone. It literally has no effect on anyone else's marriage. So there is no injury to a heterosexual couple if I marry my partner of 15 years. But denial of these rights does injure us because it imposes burdens that same-sex couples in heterosexual marriages, that heterosexual married couples don't have to bear. And this is a violation of due process and equal protection clauses in the Constitution. The anti-marriage equality people make the claim that it's always been between one man and one woman, which we know from history is not true. There were expert witnesses that testified that this is not the case at all. They argue that the primary purpose of marriage is procreation, and that gay people can't procreate, so they can't fulfill marriage's primary purpose. Well, first of all, being gay is no barrier to procreation. My wife is the biological parent of our son, so being gay does not affect your fertility at all. You can still have kids. But you're not required to. And Griswold already established that you don't have to procreate. There's no state interest in that. They claim that children do best when raised by a mother and a father, and that gay relationships are confusing to children. That's refuted by literally 45 plus years of research on families and children raised by gay and lesbian couples. Kids are not confused by parents who are in a loving relationship. They're confused by the hatred and vitriol we see from right-wing anti-equality advocates. My son, every once in a while, he still asks, whenever we pass the Chick-fil-A, he still asks me, why do you hate our family? It's funny, but it's kind of a tragic thing. You have a 9-year-old kid, he just does not understand how anybody could hate our family.
Well, it's Hobby Lobby's the same thing.
Yeah.
Oh, yeah. It's been going on.
Then they go to the religious argument. It's offensive to some religions, so requiring it will violate the First Amendment rights of religious people.
We're not requiring a man to go out and marry another man.
Right.
So I don't understand how they can use the word requirement.
Yeah, they're very creative with the argument.
That against compulsory gay marriage.
Yes, I do too.
There's a phenomenon that's been, I think Dawkins refers to it in the God delusion, called providential righteousness.
Yeah. And
a lot of it's what motivates the Westboro Baptist Church in their picketing military funerals. It's the notion that as a collective nation, somehow God is judging us based on the behavior of a handful of people. And so it is genuinely disturbing to religious people that the country condones homosexuality and in general and gay marriage in particular. That is, that doesn't have any bearing on whether we should have a right to gay marriage. But
yes.
I think understanding that is the motivation, and that belief system might help us better understand and maybe empathize with people who are sort of on the margins, not understanding what gay marriage is about. And there are the people who are so extreme that we can't have a conversation with them no matter what. Mm-hmm. But there's a huge body of people who are sort of on the fence.
And those are the people that I have a little bit more empathy for, because they are actually being abused by these people who are spewing this nonsense, not making them afraid of these changes. But there are people that are fearful that Christians are going to be hauled off to FEMA camps because.
How does it violate their First Amendment rights? Is that simply the freedom of speech and?
Well, I mean,
it's not the freedom to not be offended.
This is their religious rights under the First Amendment. They're claiming are being violated.
Yeah.
Religion or prohibiting the practice thereof.
Yeah. So there are actually 6 constitutional rights enumerated in the First Amendment. One of them being the Free Exercise Clause and the Establishment Clause regarding religious rights. And so their view is that this violates their First Amendment rights to free exercise of their religion. The thing is, they can still freely exercise their religion. And what it is they don't understand what the Constitution actually gives them the right to do and not do.
Okay.
So it's basically a misunderstanding.
So is this popular discussion, or is this actually in a court?
This was actually in the actual arguments before the court. Some of these were prompted by certain Supreme Court justices. Questions along these lines.
So I was just still wondering
how the government would square saying to people, you can't be married to more than one woman. A man cannot be married to two other men, or a woman cannot be married to two other women.
Well, since you brought that up again, Jonathan Turley actually wrote a piece on the Overby-Feldman-Hodges decision.
I'm thinking in terms of Mormonism, for instance.
Well, basically what Turley's claim was that because of the argument that, or the basis on which this case was decided, it might open up the possibility of polygamy being legalized in the U.S. What?
Multiple spouses.
Yeah, but I mean, I just don't understand how they would justify telling a man that you can't have three wives. Not three wives, but three other men partners.
The laws are all set up for pairs of people.
What law would the government have to come up with to say, no, you can't do that, other than we just don't want you to do
basically, this is one of the claims here, that the marriage equality is going to lead to incest and bigamy, that this is a slippery slope.
Incest will be involved, though.
And polygamy, like I said, Jonathan Turley thinks that this may end up coming before the court. Right now, the marriage is set up as between any two people. Okay, so if you start adding more people to that, there's probably not a problem as long as it's consensual and the relationships hold.
Any three people or any four people.
The question is, what happens when one person wants to leave that relationship? If you're in a relationship, say there's three people in here. If you get married, do you have to get married to both of the people individually? Or can you just marry one? And if you get divorced, do you have to divorce both of them? Or what if you don't want to divorce both of them? What if you just want to divorce one of them? What happens then? What if you have kids together? Do you have access to...
men can't have kids. I mean,
Who is next of kin in a three or more?
Yeah.
I mean...
One person dies, who's next of kin?
The problems here magnify. So like I said, it's probably not an issue if everything's going great. But if somebody wants to leave the relationship, then you have...
Somebody died.
Kind of a mess.
Well, that's like you said, that's a whole other issue.
That's
nevertheless, if it is ever enacted, it'll have to be enacted across the board.
Yes.
It won't just be a homosexual or heterosexual thing
Right.
or whatever. It'll have to cover everybody.
Right.
Sure. And let's see if I should.
One of the biggest problems, I think, with polygamy is you're going to tend to having a lot of rich guys with a lot of wives.
Yeah.
And you get a lot of young, horny guys that have no women. And that's not a good thing for society.
Nope.
Well, there's actually...
We already have that.
Yeah, there's actually kind of a societal argument for that, because that's one of the things you see in the Middle East, and it's one of the reasons that some people think that China is kind of a powder keg, because you've got lots of young males in China because of their preference for sons. That there's lots of young males who have no hope of ever having a wife, and how are you going to manage that
The problem they're
situation?
getting at that is that the young men in China now are going to Malaysia, Indonesia, Thailand, and getting wives and bringing them back to a completely different culture. And the mother-in-law won't accept them as mothers.
Yeah.
Won't accept them. These people don't speak the language, don't have anything in common with the culture. It's causing problems.
But historically, when we've had an excess of young males in a society, we've taken care of that problem with a massive war that killed off generations.
Yeah, but not with purpose for that reason. It just turns out that
it generates itself.
Yeah, it's kind of a self-generating.
But nowadays you have
basically,
women and men in the army.
well, no, but the thing is, this is where a lot of the jihadi culture comes from in the Middle East.
Yeah.
Because you've got a lot of young men who are poor, they have no prospects for ever having a wife, because you're in a society that allows a wealthy man to have as many as 4 wives. There aren't an excess of women in that culture. So you got,
They can get 72 virgins if they die.
Yeah.
But I don't really like to think that as many wives or as many husbands you want. I just like to think of it, numbers of people who decide to pair off. Rather you're a man, you want 5 or 6 or 10 or 20 partners, or a woman, you want 20 partners. That is not been addressed by any of them.
Yeah.
So.
Right. So with the Obergefell v. Hodges decision, so basically, James and John were married in Maryland in 2013. They wanted legal federal recognition of their marriage. So they got married right after the Windsor decision, so they could get federal marriage benefits. Arthur had ALS, so they wanted their home state of Ohio to identify Obergefell as his surviving spouse. The local registrar agreed, but the Ohio Attorney General said, nope, because this would violate the state's ban on same-sex marriage. So he refused to recognize Obergefell as Arthur's surviving spouse. They appealed to the Sixth Circuit Court of Appeals, which invoked the Baker v. Nelson decision and ruled that the Ohio law did not violate the Constitution. So this is the first time we had a split in the circuit courts, because up until then, the circuit courts have been basically falling into line with the Ninth Circuit, saying, yep, laws banning marriage equality are unconstitutional, and basically entire swaths of the country were suddenly getting marriage equality as a result. So this was a split in the courts. Once that happens, Supreme Court almost has to take the case. Because now you have a situation where 2/3 of the country has marriage equality and about 1/3 of the states don't. So this had to happen. So in a 5-4 ruling on June 26th, SCOTUS ruled that the 14th Amendment requires all states to grant same-sex marriages and recognize marriages performed.
Well, I bet you the divorce lawyers are loving this. I mean, because they've got more business.
So basically, that was the decision and the rationale behind it. And incidentally, in their opinions on that, both the majority opinion and the dissenting opinions, the justices were pretty much consistent with their rulings on Windsor. So they're following along the same mindset. So next we're moving forward. So reactions and current status. Like I said, they are losing their minds here. So, yes, the Rainbow White House, which most of us thought was fairly awesome, that apparently poses a grave threat to the security of the United States. So some of the reactions here, Mike Huckabee, he's now taking to calling it the extreme court. Completely redefined. I love Rick Santorum's question here. When did it become the law of the land that the Supreme Court has the final say on it?
1789.
Yeah. Wow. And these two guys want to be president, so. Sandy Rios, who has a radio show for the American Family Association, she's very concerned about the threat the rainbow flag poses to the U.S. with regard to a terror threat. So basically she says that the terror threat against the nation has gone up exponentially because the White House lit up in rainbow colors. We're not quite sure how that works, but anyway. And then Tom DeLay, he's been making the rounds here. He's found a secret memo from the Justice Department. And they're going to go after 12 new perversions, like bestiality, polygamy, having sex with little boys and making that legal. And they've got a list of strategies to go after churches and pastors and any business that tries to assert their religious liberty. It's coming like a tidal wave.
You know how he found that? Is when he had his head up his butt, he found it.
Probably having sex in a hot tub at the time.
Yes.
Just on the legal case here in Texas, but
yeah.
His house considered a house.
Oh no.
Well, about tablets. They're pretty survivable. Like I said, delay has been kind of making the rounds. One thing I can say about Tom DeLay is like anal sex was previously criminalized in some jurisdictions, particularly before Lawrence v. Texas. But this condition that we in the Army called anal defilade has unfortunately never been a criminal act. That's me getting paid with their ass. He seems to live there. Anyway, he's been making the rounds. He was recently on Phyllis Schlafly's Eagle Forum Live show in early June, and he was decrying what he called constitutional ignorance. And then he went on to argue that the Obergefell case was not in the Supreme Court's jurisdiction, that it was illegal for them to even hear it. Furthermore, that it's not in their authority to write law by 10 unelected, unaccountable lawyers, judges, and that this is a red line that we're drawing, and if they rule against marriage, we'll defy them. Again, he's decrying constitutional ignorance and claiming that 10 unelected, unaccountable justices are ruling. Yes.
How are they going to defy them by not marrying someone of the same sex?
I'm glad you asked. Because there's some county clerks in Kentucky that are claiming a religious right to refuse marriage licenses. Governor Beshear has told them to do their jobs or resign. And the ACLU has filed a class action lawsuit against a clerk, which, if successful, could result in jail time for clerks who continue to refuse to comply with the law. These people really need to take a look at what happened to George Wallace in Alabama. He said that he would defy the Supreme Court's ruling desegregating the schools, and he was standing on the steps at the University of Alabama, and the National Guard said, "Hey, dude." Speaking of Alabama, Judge Roy Moore initially ordered county clerks to defy. One of their daughters said, "Oh, wow, this is great. I want to come here when I get married." And they had to explain to her that this is kind of a special case. You don't know what when you get your marriage license, offering you cake and cheering for you. In Texas, the Russ County clerk, Joyce Lewis Hugel, resigned on Thursday rather than comply with the SCOTUS ruling, so go Joyce. Did the right thing. There are still 6 counties in Texas that are refusing to issue marriage licenses to same-sex couples. The ACLU joined with a Granbury couple to sue the Hood County clerk, and he has been forced to comply. And the ACLU has basically fired a warning shot across the bow and says, hope everybody takes note, because if you refuse to comply, you could face jail time. Mm-hmm. So, a deputy clerk from Loving County has said that her office is still waiting for that directions guidance from Kim Paxton's office. As of right now, there are 254 counties in Texas. 3 of the counties have not been reached for comment. 13 counties will begin issuing marriage licenses after their software changes or on receipt of updated certificates. And then, of course, there's the 6 that are currently not in compliance, but overall, the majority of counties in Texas immediately began complying with the rule. So, anyway.
When?
I checked the statistics and the numbers in Travis County. In the week following the marriage decision, there were over 300 marriages recorded in Travis County. And this is just the number that are recorded. So that doesn't mean that's the number they issue, because once they issue a marriage certificate, they don't record it until the couple brings it back completed and says, just record this. So, and they have up to 89 days to do that. So.
As far as you know, there are no possibilities of future challenges to that Supreme Court ruling unless the legislature maybe tries to rewrite stuff.
State legislatures cannot really rewrite anything. It would have to be a constitutional amendment. And
that'll take decades. If they were successful, it would be a decade-long process.
Yeah, they won't be able to do this.
A couple people brought up things about tax-free status and charities, and I was just going to add that maybe they don't realize that most churches are 501c3, because whatever they do, all that they claim, they're not
specifically supporting a candidate or a specific political process. And then your super PACs and all the other ones are 501c4s or original, in which they don't have to declare their donors, and they have unlimited now support because they're evil or
yeah.
So keep that.
A lot of churches are 401c3 and 401c4. Both they got split divisions.
They have
the hospital in things are different from the church settings.
Yeah. Churches are automatically granted 501c3 status.
Right.
They don't have to apply for it. Unlike the ACA, we have to apply for it. We also have to file forms with the federal government every year, disclosure forms. Churches don't have to do this. There's some rules about religious organizations.
And they don't have to pay taxes on their churches, and our building we have to pay taxes on ours.
For a while, we're about to get taxes.
I know, this is great. I'm glad you're working on that. Yeah, that's been
Echoing a letter writer in the paper a couple of weeks ago, I was wondering if there have been any cases of county clerks refusing to issue licenses for guns. And as a quick follow-up on the problem of unmarried males around the world and the illusion of bestiality, there's always the Gene Wilder solution with Daisy the sheep. That's an old illusion from the 70s.
Yeah.
You mentioned a little bit something about Scientology at the beginning. I don't know, there's a documentary that came out just 3 weeks ago called Going Clear, Scientology and the Prison of Belief.
Yeah, actually, I didn't mention Scientology, but it was LDS.
No, that's the Mormons. Okay.
Yeah, that's the Mormons.
All the difference confusing.
Yeah. But Scientologists think gays are like...
Scientology has had a thing in Proposition 18.
Yeah, they think that homosexuality is like some kind of disordered behavior.
We're in overtime.
Okay.
Good job. Thank you.